Hi there, you're with BQ Prime, and this is the fine print. Now, last week, the National Company Law Tribunal approved the Zee Entertainment and Sony Pictures merger. Now, none of the market participants or stakeholders expected the merger to not go through, but equally, they didn't expect that the SEBI order against Zee's erstwhile CEO, Punit Goenka, will not matter at all. Now, those of you who have been following this story, several creditors of the SL Group like Axis Finance, JC Flowers, IDBI, and IDBI trusteeship were opposing this merger on some of the grounds, saying that Subhash Chandra had given a personal guarantee for some of the loans extended to certain SL Group entities. Now, the way Z and Sony merger is structured, a non-compete fee is being paid to a Mauritius entity. These creditors said that the non-compete fee is structured to essentially defraud them. That was the first hurdle before the NCLT that the creditors had raised. On the other hand, rather, as a second hurdle was a SEBI order against Zee's erstwhile CEO, Punit Goenka. The case is still going on, where the regulator had barred Goenka from holding directorial positions. Now, the creditors and the exchanges had brought this also to the notice of the NCLT. Both these hurdles have now been cleared, given that the tribunal has now approved the merger. The tribunal essentially approved the merger, saying that the objectors didn't meet the requisite threshold under company law and that the objectors weren't direct creditors of Z, rather, they were creditors of SL Group entities, and their right to go after or recover their debt would continue against the merged entity. On the objections that the creditors had raised, the NCLT also said that it has limited jurisdiction once 99% of the shareholders of Z have approved the merger. On SEBI's order against Punit Goenka, NCLT said that it was passed much after the scheme was filed before the NCLT or approved by Z's board, and Sony Picture has every right to take up the issue at its own board level. Now, to understand what this means for corporate law jurisprudence, where regulatory orders are passed when NCLTs are considering mergers, and of course, what options do creditors of SL Group now have? To understand this, I have with me corporate lawyer Murali Neelakantan. Murali, welcome to the fine print. Murali, your first quick thoughts on the NCLT's reasoning, and then, of course, we'll come to the consequences for various stakeholders.
I didn't expect any better. So we expected when we spoke last time as well that it's a fairly simple matter in that way. Shareholders and creditors, secured creditors have approved, and therefore the scheme goes through. That has been the principle for a very long time. Occasionally, the NCLT will allow other objections, and the matter gets drawn on for years sometimes. But the simple principle has been that if the creditors have approved and the shareholders have approved, then the NCLT is not going to do very much about it. So that has been the principle that the NCLT has followed and followed it well in this case. Uh, Whether it should have also considered other objections is something we should discuss.
Sure. So let me come to first the bigger sort of hurdle that the merger was facing, and that is, of course, the Z's order against Goenka. And in which case, Goenka also went to the Securities Appellate Tribunal. Interim relief was denied to him, and he was told to make submissions before SEBI. Did you believe that this, because some of the permutation and combinations that corporate lawyers threw when we asked this question on the fate of the merger until this order came, was that look, the NCLT, what it can do is approve the merger and maybe say that look, you need to remove this clause or seek second round of approval from shareholders on the clause, given that Goenka has now been barred by SEBI, at least on prima facie level. The case will take its due appellate course. But did you also believe that the SEBI order will not matter at all, and NCLT probably, if I can use the term, brush it aside in this fashion?
I don't think they brushed it aside. I think it's a very clever way of dealing with it. They've said that the scheme is approved, but if any other authority comes in the way of executing any part of the scheme, then that order will prevail. So they're not taking away jurisdiction of SEBI or the stock exchanges here. I think in a way they're saying we have approved the scheme, but it's subject to authority of any other statutory body.
But
that may be
typically,
able to
the
pass
statutory
fast.
approvals have to come before an NCLT merger approval is given, right? But in this case, there is this large sort of question mark on because this, as I understand from the scheme documents, this is a material clause in the scheme of
Yes.
arrangement that Goenka will be MD and CEO of the merged entity for the next 5 years, effective the date of the merger. Now, given that that sort of is questionable, maybe as a shareholder, I thought that no, I wanted Goenka in this position. And now there's a question mark. I'm not sure if I want to continue with my approval. So that is a material change. So did you not think that, that should have been taken to the shareholders of Z at least once again?
If it was an issue, I would have expected, as we spoke last time, that shareholders would come to court and say, we are in support of this
Yeah,
or we are against that. I can't see, as I said last time as well, that I can't see Z shareholders coming to court
yeah,
because they're benefiting from this whole exercise. The only objection I expected was from Sony shareholders, and
mm,
obviously that's not going to happen because it's not a listed company. So
yeah,
that to me would have been the way of exploring this question. And since there was nobody actually agitating this issue very strongly, we had a very, it seems from the order, I don't know what happened in court, but it seems from the order that it was just one, little bit of
yeah.
submission to say there is an order like this that SEBI has passed. This is what SAT has done, and it's quickly dismissed as not relevant to this whole exercise by the order. Uh,
Well,
so
the arguments were made at length. The order doesn't deal with them
exactly,
in the same fashion.
I would have expected though that the ROC would have made a case out for it. So there is a whole list of fairly standard objections that the ROC comes up with, and there is a one-line reply to each one of those things. I would have expected the ROC to actually make these 2 points: that there is investigation pending by SEBI. Now, that also means that ROC should be investigating because now it has enough material, right? Based on the SEBI order, ROC has material to investigate. Instead, it has said that there are no investigations pending, there are no inquiries pending. So, if the ROC had actually wanted to make this point and say that here are the 2 issues on which we can't actually give you a clean chit, and therefore this merger cannot go through, then I suspect that the NCLT would have taken it more seriously. Now, we don't know if they said it, but from the order, it doesn't seem like they have.
So ROC didn't, and to your mind, both SEBI and the exchanges weren't the right entities to agitate this point?
No, they were, but it seems like the NCLT brushed them aside and said this matter can be taken up. It can still be investigated by SEBI, and if SEBI passes an order, then the scheme will stand amended to that extent. Which means that if SEBI passes an order saying that the Goenkas can't be directors, then they will not be directors, and it doesn't affect the scheme in any material way. That seems to be the view that the NCLT has taken. That the shareholders don't really care about this; they've approved it, and if it is subject to the orders of any regulator, so
Yeah.
be it. We don't know what will happen. Maybe regulator will not pass an adverse order. Maybe it will, but there's no reason for that proceeding to hold up the approval of the scheme.
Sure. So then, as far as the implementation of the scheme is concerned, that can go ahead.
Yeah.
Both the parties, now, I mean,
Yeah.
Z and Sony, they don't now have to go before SEBI in any fashion, right?
No, and I would have expected that they've been already set for this. So
Yeah.
everything that it need to be done and filed, they would
Mm.
have filed it on Friday or Saturday, whenever the order came out. I suspect that they would have gone off and said, we've already implemented. So in the
Okay.
time it would take to go in appeal, they would respond by saying that we've already implemented the order. We cannot undo all of this. So we've issued the shares, we've done the allocations, all the shareholders have got their shares, registry has been updated, all of this has already been done, and it cannot be therefore undone. I would have
So,
expected if they are sharp, they would have done that. I would have done that in their case.
okay. So then now, okay, now what happens? The Goenka is supposed to make submissions before SEBI.
Correct.
Uh, and let's assume that, for argument's sake, that there is an adverse order which
Yeah.
goes to SAT, and then let's say whichever party loses goes to the Supreme Court, by
Yeah.
which time considerable time has
Yes.
passed,
Yes.
and the scheme has become effective, so to speak.
Yes.
And
Absolutely.
I would think that on the next very next day, can Goenka then become the MD CEO, given that these proceedings are pending, or Sony will have to sort of actually come up with somebody, another personnel in this position, given that the appellate process is going on parallelly.
So I suspect that, as I said, if I was in their place, I would have implemented the scheme today.
Yeah.
To have natural justice and due process. Now that could take months. Then you have the possibility of several appeals, and that could take months. It could take years. Who knows? So if they're quick,
So at what point do we see the gravity of SEBI's case reflect in this merger scheme? Whether we have now the merged entity at play here.
uh, it's very difficult to say because you have parallel tracks, and we don't know what the speed of each of them is and whether they will ever intersect. So it could happen that SEBI gives them a fair hearing and then finds at the end of that process that, in fact, there have been financial irregularities and they should be prevented from being on the board of companies. Now, that will go into another appeal process.
Mm.
And for that period of time, he may not be able to hold office.
Okay.
So there will be a temporary uh, vacuum there, let's say. And if that order is then upheld in appeal, then the vacuum will get longer. If it is overturned in appeal, then he'll be back. So it will only be temporary. So it's a possibility that you could have situations where you have these temporary vacuum where, because of an order in appeal in this matter or an appeal in the other matter, you could have phases where he could be out, and that could be it could be 5 years. Who knows? We've known NCLT matters to go on all the way to the Supreme Court for more than 5 years.
And
At that point, it becomes infectious.
in the interim, do you believe any developments on the Sony board front? Because that's what the NCLT has said, that Sony can very well take this up at its own board level. You believe?
Exactly. But considering that they're already hurt by the financials if this fraud is proved, and they have done nothing about it, I would have suspected that somebody on the Sony side would have said, we reserve the right to perhaps rework the shares on a future date, or we'll get some form of support from the SL group that if this money has disappeared and it has to be returned, then we will get some comfort around that. None of that seems to be there in the order. So maybe Sony believes that that's money is gone, or even if it is gone, it still the valuation holds up, or it's believes that the money is not really gone. It's got better information than SEBI or the stock exchanges, and is confident that the money is really there. In which case, there's nothing to be done. So I'm not really sure what the Sony thinking on this is, but these seem to be the two possible strategies.
Okay. And what sort of would become of this promise of making Goenka MD CEO? Would you think that Sony would want to remedy that in some way in the scheme today, or they'll play it by the year and see where the SEBI investigation goes?
It depends on how desperately they need him as CEO, isn't it? So if you do want him as CEO, then you can say it's all subject to future orders. If you don't want him as CEO, you could say, this puts the whole commitment that we made to you under a lot of stress. It's not good for the company, and therefore we'll remove you. So I'm not really sure what they want out of this, but they can play it both ways.
Okay. All right. Now let me come to some of the creditors who,
Yes.
are SL Group creditors. Um, it seems reasonable to say that, look, your remedy against the merged entity
Yes.
will continue to hold, and
Yes.
so that's not the reason to hold up this merger. That argument seems reasonable to me.
It does, and in fact, almost all of the objections seem to be hinged on this issue. And in the order, it seems to address it time and again by saying the merged entity is actually stronger financially, and
Yeah.
therefore there is a better chance of you recovering against the merged entity with a higher net worth than against Z, and therefore you really can't have any claim. Uh, the other objection, of course, is that you have no locus because you don't have a claim against Z. Uh,
Mm.
and all of the proceedings where these claims have been agitated So they've been agitated in the DRT, they've been agitated in the commercial court. None of those courts or tribunals has actually helped the creditors by saying, we will injunct you or grant you some relief. So they could have granted an order saying, if any money is received, it shall be kept aside to settle this claim, or we will garnish it, or somebody needs to give us a bank guarantee for it. Any of those reliefs could have been granted. The fact that they were not granted seems to have given the NCLT a bit of strength to say that, listen, you don't really have a claim against Z, nobody's granted you any relief. These are at best disputed, and they can't come in the way of a merger, which I think is a very practical and pragmatic way of dealing with this. And it'll help many other cases, I'm sure, before the NCLT.
Yeah, and the fact that the NCLT didn't even go down the road of figuring out why the non-compete is getting paid to Mauritian entity also gives structuring leeway to similar
Yes.
transactions, right?
Yeah. So one of the contentions or objections there is that this is money that's really owed to Subhash Chandra, which is then being paid to Mauritius, uh, and therefore, it's money due to one of the creditors of Subhash Chandra under the guarantee. To which response is quite simple, which is that you can't have it both ways. You can't say it's illegal and I want to have a bite of it. The other thing that's said in the order is that you really still continue to have a claim against Subhash Chandra, go get it. They haven't really dealt with this issue of, is it really a diversion of money from Subhash Chandra to Mauritius? Because they're saying the only people who can object to that are the shareholders, and they voted for it. And those shareholders include institutions. The promoters don't really have control because they only own about 6% or
3-4%.
3% of the company. And therefore, you can't have any claim because nobody's objected. So it's like saying that even if it is all completely wrong, why has nobody else objected? And because nobody's objected, it should be fine. So there's a presumption that everybody's approved it, and therefore they've all done due diligence, and nobody has problems with it, and therefore the NCLT will not look any further.
So is it, I mean, last question, Murli, then, is it safe to assume that future mergers and schemes of this nature, um, shareholder approval will be primary? And even if there are allegations of financial irregularities, of funds getting diverted, of maybe some financial institutions getting shortchanged in the process, it's not going to be the NCLT which will stop the merger on these grounds.
If this order continues to be good law, and I wish it is, it should make it easier for a lot of companies to get their mergers done more quickly. It's not been the case in the past because you have had too many people intervening and objecting, and that process goes on forever. So the little silver lining on this is that if creditors and shareholders approve, the ROC gives you a clean chit, then frankly, nobody should be objecting to a merger and should go through fairly quickly.
All right. Do you see one promise last question? Do you see any of this getting appealed in any way before NCLAT?
I think it will be appealed. It doesn't matter how good or bad the order is. India, it seems to be that there will be an appeal. The cost of an appeal compared to the cost of a win is worth the gamble. So I suspect that there will be the regular two appeals, one to the NCLT and one to the Supreme Court. And who knows what will come out of the SEBI investigation. If something comes out of that, then it will help the appeal process.
All right, Murli, we'll stay on top of this gamble if it plays out. Thank you very much for joining us with your thoughts on the fine print. And thank you so much for watching.
Thank you.